All right, well, it's officially 12 o'clock, so we'll go ahead with our introductions. I see that we have a couple more guests joining us today. I'm very excited. Thank you again to everyone who is joining us for our very first NCI Live Zoom event. My name is Brian Stanley, and I am the new event and facility coordinator with NCI. I joined back in February 25th, so I've only been here for a month and a few days, but I would love to introduce our guests. Just some few housekeeping. We are keeping everyone on a mute for their audio and visuals, so that way we can have a smooth presentation. If you do have any questions, please feel free to use the chat system, and I'll make sure Mr. Haley gets those questions at the end. And if you are joining by phone and you would like to ask some questions, feel free to shoot me an email at bstanley@newcollegeinstitute.org, and I'll make sure he gets those questions as well. And without any further ado, I'd love to introduce Mr. Robert Haley from the Estate and Elder Law Center for his presentation on estate planning at 5 at 55.
Thank you, Brian. This is certainly the first for us as well, too, doing this presentation on webinar. We miss being there at the Institute with you all, but we hope we can get things done and give folks some information that is certainly timely at this time. So we are the Estate and Elder Law Center of Southside, Virginia, with offices in Bassett and Danville. Go ahead, Mal. So some of the things that we do here, basic estate planning, we do Medicaid planning and asset protection for folks that are going into the nursing home. We do estate and trust administration, which is referred to as probate work, life care planning, special needs planning, guardians and conservatorships for folks that don't have their powers of attorney in place, fiduciary services, and pet trusts as well. Go ahead. I am a certified elder law attorney, certified by the National Elder Law Foundation. I am also a charter member of the Virginia Academy of Elder Law Attorneys, and since 2007, I've been named as super lawyer in the state of Virginia in the field of elder law. One other thing that hasn't got up here yet because it's fairly new, this year I am serving as the chair of the Elder Law and Special Needs section of the Virginia Bar Association. So, go ahead, Mal. I'm also a member of the Council of Advanced Practitioners. This was established by the National Academy of Elder Law Attorneys a few years ago as an invitation-only council for those practitioners in elder law that are deemed above and beyond. You can see the bottom of the screen. You have to be a member of NALA for at least 10 years. You have to have the highest possible rating by Martindale-Hubbell. That's a lawyer rating firm that rates a lawyer by ethics and by proficiency. And you also have to be a certified elder law attorney. There are roughly less than 100 of these in the entire nation. Go ahead, Mel. I'm currently working on a PhD. I have a Master of Arts in Public Administration. I have a law degree, and I have a bachelor's degree that I got while I was in the Air Force. You'll notice it says University of Maryland. You'll notice it says the European Division. I graduated in Heidelberg in 1991. Go ahead, Mel. I was in the Air Force for almost 9 years, stationed in Greece and Germany the entire time. I was named most outstanding NCO in my field in Europe in 1989. Had a very good Air Force career. I enjoyed it a lot. Sometimes I wish I'd never left. Those days are few and far between there. Go ahead, Merle. Our firm, we have a couple of contract employees, Sandy Vernon and Stephanie Wagner. Sandy helps us in the fields of when we have clients with special needs or those that suffer from mental illness. Stephanie is an RN. She's an instructor at PH. She helps with our life care planning program. And then working for me full-time is Mr. Rohr, our marketing and community liaison. Joanna Smart, who is also a licensed practical nurse. She's on the staff primarily in the life care planning field. Grace Young is my primary assistant, legal assistant, and my wife, who is the real boss, runs the entire firm. Go ahead. All right, so today we're going to talk about the basics of estate planning and probate. We're going to be talking about, I have a lot of people that will come in and they want to ask about this or that or this, and we always go back to the basics. You know, anytime you've got to lay the foundation in place before we can go on anywhere else. So these are the foundational documents that any plan would start with. Go ahead, Mel. And so we're going to look at 5 documents that every person should have by at least the age of 55. And we know that's an aspirational standard. A lot of people procrastinate when it comes to this. We've had a lot of people get in touch with us with this COVID environment going on that had failed to get their documents in place and trying to put them in place now. So these are the 5 things that we're looking at for our clients. Go ahead. So the first thing we're going to look at is wills and or trusts, durable power of attorney, healthcare power of attorney, living will, and then we're going to talk briefly about digital directives and digital inventory. As more and more of our life goes online, we have to also take steps to plan for that as well. Go ahead, Mel. So we're going to talk about the importance of estate planning, and then we're going to go through the documents: the will, trust, powers of attorney, and the digital directives. Okay. People ask me, they say, well, I don't have an estate. Well, yes, you do. If you own something, you have an estate, because an estate is simply everything that you own. And so estate planning just means that you want to put in place the plan that you use to pass whatever you own to whoever you want your heirs to be at your death. That's as simple as it gets. Now, based on the assets that you have, that would dictate how complicated the estate plan needs to be. Go ahead, Mo. So, why does one need to do this? Well, other than the obvious with the COVID virus going on nowadays, people are getting older every day. As I said, many of my clients have procrastinated for years trying to come in. Just in 2015, less than 5 years ago, 5.3 million were diagnosed with Alzheimer's. This number in the next 5 years is going to increase to 40%, and 1 in 9 older Americans will have dementia at some point in their life, which technically means they're going to become incapacitated, which means they have to have these things done before that incapacity hits, or we're forced to take other more drastic measures, usually resulting in court action. Go ahead. So, as we said, with procrastination, 55% of Americans have no wills, only 41% have living wills, only 39% have health care power of attorney, and only 40% have done anything what we'd call an estate plan, to have the whole plan put together. And what this drive with the 5 and 55 is trying to do is obviously to raise those numbers, to raise awareness of what needs to be done, and hopefully prompt people to act. So, again, the 5 documents: wills, revocable living trust, or an asset protection trust, durable power of attorney, which you would use to appoint someone to handle your financial affairs if you're not able to, healthcare power of attorney, and living will, where you're appointing someone to make medical decisions and where you're giving your own end-of-life decisions, and the digital directives or digital inventory. Go ahead. All right. A will is simply a legally binding statement directing who will receive your property upon your death. And it's usually made up of 3 parts: specific bequests, where you have a specific item or a specific amount of money you want to go to a specific person. There'll be portions in your will that will talk about not only your personal property, but also your real property, your real estate. And then at the end, there'll be a residuary clause that basically says, all the rest, residue, and remainder of my estate, which means everything else goes to, and you would name who those heirs were going to be. Go ahead. So, one of the biggest reasons to do your own will is because by doing a will, you get to appoint who the executor of your will is going to be. This is a very important decision, and that alone is usually worth the cost of doing a will, even if you have a very simple estate. Because by naming your own executor, you have the ability then to waive surety. See, without this waiver in your document, when your executor goes over to the circuit court to qualify after your death, without this waiver, they're going to have to post a surety bond, which means they're going to have an insurance agent over there with them, and they're basically going to have to buy a policy of insurance to protect the state against any bad act that they may do, in case the executor decides to use the money or waste the money or, worst case scenario, steal the money. So by you being able to appoint your own executor, you're appointing someone that you trust. And by trusting them, you can waive their requirement that they post a surety bond. So if you die without a will, no matter who is going to administer your estate, whether it's a trusted spouse or a child, they will have to post a bond. So usually by doing a will, the cost of the will is roughly less than the cost of a bond in many cases. Go ahead, Mel. So if you have minor children and you pass away without a will, you've given up your right to put down who you wish to be the guardian of those children should something happen to you. Now, while your appointment in the will is not going to have a legally binding effect, they will be able to take that will into court and show the juvenile and domestic relations court judge, these are the people, they wanted me to be the guardian of their children, and barring some unforeseen circumstance, the court will honor your wishes and name those people as having custody of your children. And this also would come into play if you happen to be the guardian for an adult disabled child. You can leave that in your will who you want to take over for you should you pass away first. Go ahead. So, with no will, there's going to be delays. The assets are going to pass by construction of law, which means for many folks, it would pass to their spouse, or if their spouse had passed away, their property will pass to their children. But if there's been a previous marriage and there are stepchildren involved, then the law is going to dictate a division of the estate, and that may or may not be what the person wanted to happen. So by doing the will, that uncertainty is put aside, and the will lays out exactly who they want those assets to go to. Without a will, there could be family disputes, a lot more costly on both legal and administrative sides. Dependents, if you have minor children, they may have to wait for funds to be able to support them because it would be held up by the probate process. And it just adds a lot of stress at a time where there's already stress from the death of a loved one. Go ahead. So, that's a will. Now let's talk a little bit about a trust. A trust is simply a legal arrangement whereby one person or institution called a trustee holds legal title to property for the benefit of another person, the beneficiary. And the rules for the trust are set out in the terms of the trust. Now let's stop right there. A lot of times you may see on TV or see ads on the internet of, these trust programs that you can buy, and the thing that everybody should have a trust, that they try to scare everybody into doing a trust. We're made up of 50 different states in the United States, and there are many states where you would want to do a trust, just any family would want to do a trust. Because the rules of probate are complex, they're costly, there may be a probate court that you have to go through. So states like California, New Jersey, Illinois, you would want to avoid probate like the plague. Virginia has a very relatively easy probate process. So while probate avoidance is one of the main reasons for doing trust, your estate may not dictate that because your estate may easily be settled going through the probate process. And that's something we look at with every client. There is no one size fits all. Go ahead, Mel. So the advantages of a trust, as we just said, sometimes people want to avoid probate. Tax savings, this is technically still true, although the amount you would have to pass under a will would have to be much, much more to get even approaching the estate tax. The estate tax wouldn't even kick in for an individual till over $5 million. So estate tax purposes is not really a primary advantage of a trust. Trusts are private. They usually do not have to be recorded in the courthouse. Most of the time you can just file a certificate of the trust. And that way for folks that privacy is a huge concern, a trust would take care of that. Now that being said, I'm in the deed room quite often in the circuit court clerk's office, and I've yet to see people in there just going through the will books looking to see what people had left somebody. So while technically privacy is an issue, it's not an overriding issue. These last two are very important though. Durability. The concept of durability means that should you become incapacitated or even pass away, your trust keeps going. It's not held up by probate, it's not held up by death, it's not held up by death certificates. The trust keeps going. The trustee may change, especially if you were your own trustee. A successor trustee may have to take over, but the trust, the operation of the trust keeps going. This is very important when people may still have minor children and they would leave their property in a trust so the trustee could continue to pay bills or do things that the minor children needs funding for. Same thing with adult disabled children. So if you're worried about a funding stream or maintaining things like that, a trust may be appropriate for your situation. An asset protection trust comes into play for those of my clients that are trying to protect their assets from long-term care costs. And those are entirely different trusts, and not most of the time, they are always irrevocable trusts. So they're not appropriate in every situation, but they are another tool in the toolbox that we can use for the appropriate client. Go ahead. Talking about that, here are the types of trust that we can use. The revocable living trust, and this is the one most people see referred to, and they see the software ads about. That trust is basically for asset management purposes. It doesn't do anything to protect your assets, but it does get them all together. Management is all under one house, and you do avoid probate, and you avoid any time delays at your death if you're worried about your assets having to go through probate or being held up. Irrevocable trusts, as we stated, are usually used for asset protection purposes. A lot of people, well, every will that we write will have one, and some wills will have a more complicated one, but a testamentary trust is in your will. It would state that no minor can inherit under this will, that if someone under the age of 18 or even 21 or 25, if they inherit, they don't get their money outright until they reach that age. That money is held in a testamentary trust for them until they become of age. And while 18 is the minimum that you would want to use, I find that a lot of my clients will want to push that out to 21 or maybe even 25. The theory behind that, one, is the person is even more mature than they would be at 18, and even more so if they're 25, if they've decided to go to graduate school before that, we don't want those funds to be counted on a financial aid application. So if we could hold those funds back until age 25, that would keep that student from being able to keep getting their financial aid benefits without having to count those trust funds. We'll use a special needs or a supplemental needs trust for someone who is already on public benefits and they may get some sort of windfall, such as the sale of a house or a personal injury settlement. And finally, we can do an IRA beneficiary trust if you don't want someone to inherit your IRA outright, or you want to force them to take that IRA over time. Because recall that IRA money has never been taxed. So if all that money gets taken at one time, it's all going to be taxed as income in 1 year. So sometimes my clients will want to force that heir to take that IRA over a period of time so they can stretch that tax out over the same period of time. Go ahead. So, why do I need a trust? Can't I just give my assets away? Okay. You can always give your assets away, but it's also going to put you in a lot of trouble or put you potentially at risk. Because when you put your assets in somebody else's name, you run the risk of that other person's debts or creditors coming after your money. You're risking that this person's not going to die before you. You're worried about disability. You're worried about divorce. And quite frankly, in rare situations, you have to worry about the person you're transferring asset to, about their dishonesty. And a lot of times it may not be outright theft. It may be, well, I needed some money, so I took some of mama's money out of here with the intention of paying it back. So gifting is never really a smart plan unless it's done in conjunction with an estate plan through your attorney's process. Go ahead, Mel. Now, we've talked about wills and we've talked about trusts. Right now, this is one of the most important documents that you can have, and this is what a lot of my clients or people are calling in about. because the durable power of attorney for a lot of people is the most important and powerful estate planning document that they will execute. Because this allows you to appoint another person or an institution to act as your attorney in fact, to step in and manage your affairs if and when you become incapacitated. Now, the power of attorney that I do for a 20-year-old is totally different than the power of attorney I do for a 40-year-old, as opposed to the power of attorney I do for someone retired. Because we're planning for incapacity. The incapacity for a 20-year-old, most likely we're planning for, is a very short incapacity, car wreck, brief illness. For a married couple or a middle-aged person, it's roughly the same thing, short-term disability. When you're getting to a retired person, you have to plan for an incapacity that could be chronic. You're planning for the possibility of dementia that's not going to get any better. So each of these powers of attorney over your lifetime has to give your agent more and more power, because with the length of the disability being riskier, you've got to give your agent more power to do things over time. So let's say you become incapacitated without a power of attorney. Well, it's likely we're going to be going to circuit court to have a guardianship or conservatorship established on your behalf. That's going to be much costly, where a document may be a couple of $100s. The guardianship petition in court case is going to cost you a few $1,000s. So then basically what I tell my clients when we're having to do a guardianship, just going to court is the beginning of the process. Once you become a guardian, you're under court supervision for the rest of your ward's life. You're going to have to post a surety bond for the rest of their life. And so the process, while the court case is over, the guardianship or conservatorship process has just started and it never ends. So it's really important to get that power of attorney done to avoid all of this. Go ahead. So the healthcare power of attorney. Where the durable power of attorney, you're planning for someone to make business decisions, pay your bills, do things like that. Your healthcare power of attorney is appointing someone that you want to make your medical decisions for you if you're not able to voice those decisions on your own.
Hi, Mr. Haley.
So in Virginia, yes.
Your screen stopped sharing. There we go.
Okay. Thank you.
All right. You're welcome.
So the documents that we provide to take care of this incapacity is the healthcare power of attorney, and we pair that with a living will. There is a statutory form in Virginia called an advanced medical directive that kind of combines the two into one, but we like to, I've had almost 25 years of experience of doing this, and the easier you can make it on folks, the better it will be, and the more apt it is to be respected. So we break that down into two separate documents. Go ahead, Matt. All right. Your healthcare power of attorney, your proxy, or your agent will be able to talk to doctors, ask for second opinions, and carry out your wishes. Now, that is the key. You want this agent to carry out decisions and wishes that you have already made. So in order to do this, you have to think about and decide on how you would want your health care and those decisions to be made. And one of the things we do to help our clients think about these things is we give them what's called a healthcare toolkit. It's a document that was created years ago by the American Bar Association, and it asks you a series of questions about what you would want to happen if you were faced with different medical situations. And it makes you think about what you would want to happen. And then by working your way through this toolkit, then you're able to sit down with your spouse or your loved one and discuss those things with them. Because what you're trying to do with a healthcare power of attorney is you don't want to force your agent into making the decision on their own. You don't want to put that burden on them. You want your agent to know what your wishes are ahead of time. So then if they are ever called upon because of your incapacity, they know what you would want, and they have no problem voicing that decision. So let me give you an example. My father had brain cancer, and he had an operation near the end of the fall in one year, and once the surgery had happened, they realized there was much more cancer there than they had thought, and there was really nothing they could do. It was inoperable. And so at that point, from that time on to the next time my father went into the hospital, we had had time to discuss a lot of things regarding his health care. So about 6 months later, when he was in the hospital, he was in critical care, and I saw a machine being wheeled into his room, and I stopped them, and I said, "What's this?" And they said, "Your father's having trouble breathing. We want to put him on a respirator." So a person always wants every chance to recover. So my question was, is it possible that my father just needs this machine for a short period of time, and then he'll start breathing on his own? They said, yes, that's possible. I said, by all means, hook it up. Because again, you always want to give everybody a chance to recover, even if they have a living will or end-of-life statements. About 45 minutes later, 2 more machines came rolling down the hall. I stopped them again. "What's this?" They go, "Well, your father's breathing's gotten worse, and his kidneys are shutting down, and this and that." And I told them to stop. Get all the machines out and just keep my father comfortable. Now, I had no problem making that decision because it wasn't my decision. My father had told me that's what he wanted basically every day for the previous 6 months. So that's what you want to do in your situation. You want to let your agents know what your wishes are, and so when that time comes, the burden of making the decision is not on them. All they have to do is voice the decision you've already made. Go ahead now. Now, your living will is in conjunction with that health care power of attorney. The living will is going to spell out what you want to happen when you're facing with an end-of-life situation. Now, we're talking end of life. We're not talking terminal diagnosis. We're not talking, you just heard you have inoperable cancer. We're talking about months or years down the road, and now you are really, truly facing end of life. This is where we need to know what your wishes are regarding medical treatment. Specifically, whether or not you would want to continue a feeding tube, artificial nutrition or hydration, how long or whether or not you would want to be on a machine that would be keeping you alive, such as a respirator or a ventilator and things like that. And, the other situation that is addressed in the living will is one of persistent vegetative state or a coma. And so all those things are addressed in the living will. As I said, we've done this for a while. One of the other things that we have to put into certain living will situations is if you have some sort of medical illness that would have to continue even though you were in the dying process. So let me give you an example. I was named guardian of a lady that was currently in Danville Regional Hospital, and she was already incapacitated, and she was also dying of breast cancer. So when I became her guardian, we found a nursing home for her to go to, and she was in the nursing home for a few months. When it became clear she was about to pass, and so we wanted to move her to hospice to make her more comfortable than being in a hospital. Now, as many of you may know, when you go to hospice, your medications stop, except for comfort medications or for pain or for palliative care. What no one knew at that time was the lady that I was guardian for was also a sufferer of bipolar disorder with a schizoaffective feature, which means she could become schizophrenic at times without her medicine. And she did. She had to go from hospice to the psychiatric ward. And it took us a few days to get hospice to understand, yes, we know she's dying of breast cancer, but she needs this medicine every day that she is alive to keep her under control. And so we found that we address these situations up front in the living will so as to alleviate problems such as that in the future. Also, if you happen to be on dialysis, we need to put special language in a living will as well. Go ahead. So again, we're addressing end-of-life situations. If you sign a living will, you still get health care, you still get treated. There's not as much confusion as it used to be. When I first started doing this, I would have people refuse to sign living wills because they thought that was giving up their right to have medical care. But we're looking at end of life, terminal condition with no chance of recovery, or the coma, the persistent vegetative state. Go ahead now. So, without these documents in our planning focus, upon incapacity, you haven't named anybody that's going to keep paying the bills, nobody to manage your estate or your property, who's going to make your health care decisions known. So these legal tools are the answer to all of those problems. And whether or not you need a simple set of documents or a more complex set of documents is totally dependent upon your situation. There is no one-size-fits-all, as we said before. Go ahead, Mel. So the last thing I wanted to just touch on briefly is, as I said, if you look at your smartphone, you will find apps. I usually have my phone with me, but I didn't bring it today because I'm concentrating on you all. I have my bank is online. I have a Acorns account, which is online. I have a Coinbase account that is online. You have all of these accounts that are online now, and you really have to take specific steps to take care of those digital accounts and or digital assets after your life. And leaving your passwords to someone else is not the way to do it. Technically, under federal law and under those terms and conditions that we all click and agree to, but we never read, a lot of times sharing a password is a felony. And if you know what cryptocurrency is, or Bitcoin, or anything like that, the last thing you want to do is leave your 27-character number in the wrong spot, or lose it for that matter, because if you lose it, you've lost access to all of your Bitcoin or your cyber currency. So there are ways now through digital directives and digital inventories, and of course there have even companies that popped up where you can make arrangements ahead of time to shut down your digital life at your death. You can give this digital trustee, in lack of a better word, the authority to go in and close accounts. If they're closing accounts that have finances, you tell them to close the account and move the finances to your executor, to your probate estate. So there's a lot of things that you need to take care of, and some of the more simpler things just by family photos and different things like that. You know, a lot of times we can put those on a thumb drive. A lot of times you can put those in a Google Drive and share them with somebody so they haven't lost access to them. So this is just something that people need to begin to think about as more and more of our life goes online and becomes digital. Go ahead. See, I think I've hit most of that. Like I said, we have a couple of vendors that we refer folks to, that we work with, that are able to take all of this information down. It's all confidential, and only upon notification of your death would they come in and act to close those accounts and take those things over. It prevents mischief. You know, I hear stories, like I said, you do this as long as we've done it, you hear stories about somebody found a password, different things like that. So again, as more and more of our life goes online, we have to take different steps, and we have to take the right steps to protect those assets. Go ahead. All right, and like I said, I am Mr. Haley. We have an office in Bassett and Danville. I go back and forth. I'm usually in Bassett 2 days a week and in Danville 2 days a week. Our website is vaelderlaw.com. On there you can find resources, sign up for our newsletter, subscribe to the blog, and we're also on Facebook, and we also have Twitter and LinkedIn for those social media outlets as well. I guess, Brian, this is the time for any questions?
Yes, sir. So again, if you have any questions, feel free to use the chat menu. If we don't have any questions within 2 minutes, I will unmute a participant one by one and just ask if you have any questions. especially for those
Okay.
who are going via their phone, so that way they can ask that question now. But I do want to thank you again, Mr. Haley and Mr. Mal, for joining us and helping us get this done today. I think it was very exciting. And again, this was our first event, so we had no issues during the presentation, so that's great.
No, and the other thing I think that this points out to folks is we can even do your consult via video conferencing technology. We have our own Zoom account, and if you wanted a video conference, we would send you the link. It's your time for your appointment. You just click the link. I'd be there. I'd be able to see you if you have a smartphone or an iPad or a webcam on your computer, and we could get this done. And one of the things that I've been doing a lot of in the last couple of weeks in my duty as chairman of the VBA Elder Law section this year is we've been trying to work out the processes for notarizing documents, watching someone sign over video conferencing technology. So a lot of this COVID virus is making people think ahead, plan ahead, and we're putting things in place now that we'll be able to use in our practice from now on.
I agree. I think that's a great thing to mention, and I think that's, you know, the world that we're currently living in, and even after all this is all settled, I think that's a great opportunity for your clients.
Right.
Awesome. All right, well, I'm going to start unmuting people one by one. I want to start with Sarah. So Sarah, if you have any questions, let us know. If you don't have any questions, just say, I have no questions, okay? All right, Sarah, your audio should be unmuted now. Can you hear us, Sarah? Okay. Oh, this is from Sarah right here. She just sent us a question.
Okay.
She said, if you have assets in more than one country, do you need separate wills and powers?
That will basically be decided on the country where your other assets are. Most of the time you will have to have two separate wills, one that will be acceptable in your country outside the United States where you have property. I have a colleague up in Northern Virginia who specializes in matters like that for expats or for people that are immigrants to America but also still own property in other countries. And I can consult with her, and we can take care of that also on a case-by-case basis.
Awesome. Sarah, did that answer your question? I'll give her some time to type that out. She said her audio is not coming through.
Sure.
All right. Ellen, do you have any questions for Mr. Haley? Sarah said thank you.
Thank you for being online, Sarah.
All right. Ellen, is your audio working? Oh, okay. Ellen says she has no questions.
Okay.
Is there anyone that has any questions that wants me to unmute them or send them via chat? All right, I'm going to move to our two guests who are on their phones to see if they have any questions.
Okay.
Hi, this is Brian Stanley. Do you have any questions for Mr. Haley?
No, thank you.
All right, thank you so much. Hi, do you have any questions for Mr. Haley?
This is Helen Hawkins.
Oh, hey, Helen, do you have any questions for Mr. Haley?
I do have a question. First of all, I want to say to him, I thoroughly enjoyed that presentation, and that was very informative. I want to ask about if someone does not have a will and they have financial money in the bank, and I just want to know that when you file those taxes and they haven't moved that money and you take all that money out at one time, you have to pay taxes on all that money?
No, ma'am. The only thing you have to pay taxes on is money that's in qualified accounts, such as an IRA, 401k, a 403b, the monies that you put away that you don't pay tax on when you put it away. Only when you, then those monies, if you take them out all at one time upon the death of the person that owns the account, then the tax comes due. If you have money in a savings account, checking account, brokerage account, or a Roth IRA, a different type of IRA, that's money that's already been taxed, you don't get taxed again.
Okay. Okay. I also would, and I'll get that from Brian, I'd like to talk with you offline about, about estate, and, get your fees and things for doing that kind of thing.
Sure, just give us a call at the office or shoot us an email.
All right, thank you.
All
Very
right.
welcome.
All right. I am now going to unmute Miss Simone's phone. Hi, Simone. Do you have any questions for Mr. Haley? Oh, I think she... Okay. Let's see if Miss Gail, do you have any questions? Okay. Well, that is everyone that was logged in. So again, if you have any questions for Mr. Haley, we will be glad to share his contact information on our Facebook page, or if you'd like that information, just give me a call at 276-403-5605, and I'd be glad to share his information with you. I do want to invite you all to join us for next week's live session, which will be on the Thai New Year with Culture and Cuisine, presented by Chris Neblett, who is actually our HR and board liaison here at NCI, and that will be next Wednesday from 12 to 1, so please be on the lookout for an email with that link, I'm sorry, and on our Facebook page as well. And I'm hoping that Mr. Haley will do this again for his next event that was scheduled for May 6th, so we could do another session like this. And we'll, of course, do a lot more. Awesome. Well, again, thank you so much. If you guys have any other questions for Mr. Haley, please be in touch with him or myself, and we'd be glad to get that information to you.
Thank you, Brian.
You're welcome. Thank you. And again, thank you guys again for joining our first ever NCI Life Zoom session. So I'm going to count this as a great success, and I can't wait to share it with everyone else at the college. All right. Well, I will go ahead and end